Do we include automobile loans in a bankruptcy?
You have to include all obligations, all loans, all creditors in your bankruptcy, and that includes the automobile loan. Now, that doesn't necessarily mean you don't get to keep your car, however.
So how do I keep my car?
Well, you keep your car in the old-fashioned way. You pay for it. That's how you keep your car. If you make the payments, you'll generally get to keep the car. Um, there are some other circumstances that might affect whether you'd get to keep a car in a bankruptcy, but if you depend on that car and you really want that car, we just won't do a bankruptcy for you if that's going to be a problem. But it rarely ever is, because usually people do get to keep their cars in bankruptcies. Now, one reason why you might not get to keep your car in a bankruptcy is if you have too much equity in the car. If your car is worth so much more than what you owe and you don't have an exemption for that equity under the law. But guess what? The exemptions, at least the California exemptions that we use in bankruptcies here in the Southern District of California, where I practice, are fairly generous. And under most circumstances, you wouldn't have so much equity in your car that it couldn't be covered by the automobile exemption plus what's called the wild card exemption. That wild card exemption is about $23,000, so you will get to keep it. Now, you also have to do, under present law, something called reaffirmation of the debt.
What is a reaffirmation?
Well, a reaffirmation is an agreement, and it's an agreement, often cars are involved in this, but other kinds of secured debts are involved in it, and even some unsecured debts are involved in reaffirmation. A secured debt is one in which something that you owe is used as collateral that can be claimed by the lender if you don't make the payments, and that can happen even after you've discharged the debt in the bankruptcy. If the collateral is still in your possession and the debt has been discharged and you're not making the payments, well, the owner can repossess the collateral. Well, the other thing you can do is you can reaffirm a debt. Reaffirming a debt is signing a contract with the lender just as though you never did the bankruptcy. And in the reaffirmation agreement, what you're doing is you're agreeing to make the payments. And as long as you do make the payments in accordance with the reaffirmation agreement, in general, you'll get to keep the collateral, like a car, or maybe you bought a big screen TV or something else on time, that's something that might be worth enough so that the person who holds the collateral or the company that holds the collateral will actually want to come and take it away from you. Believe me, it does happen with cars. People do repossess cars. I think we all know about that.